the general language of the statute is practice year. And you recall that we submitted that the respondent, first respondent had mentioned anniversary as a way of computing years earlier, but in their oral submissions, they have not really talked about that. They have not emphasized that anniversary, partly because it has no basis in the relevant law, LSK Act, Advocates Act, which, my lords, the court will appreciate that the Act sees practice here as something flexible, that the CJ, the Council of the Senate and CJ have some discretion in working on what a practice here is. And there is no doubt whatsoever, although they were imputing that the petitioner, the only non-full calendar year was the first year of admission, that was 03. In the other years, he took the practicing certificate for the year 1st to 31st January, which doesn't call for any other further interpretation. It's only the first year of admission that it was from 19th June to 31st December. But in any case, that's being regarded as a year, practice year, even by the respondent in terms of charging the fees to be paid. And indeed, when this advocate and others took pupils, they counted the certificates. They didn't go doing the anniversary. So that's also very, very important. They counted the number of certificates, practicing certificates that one had. I would then quickly go to the members' right to vote and vote, which my lord also raised as one of the questions that you posed to the respondents. The issues of section 12 and section 18. How 18 is limiting a constitutional right under 36 and 38 and a statutory right under section 12. My lord, this issue has been contentious, and there was a supplementary affidavit that was filed by the first respondent. What is clear is that so far there is no evidence on record. We raised it at first, and up to now there is no evidence from the first respondent to show that there was a notice of a meeting that approved the equivalence of judge of the Supreme Court, 15 million. There are no minutes, there are no records of which members of the LSK attended that meeting, names, no signatures, because that has been the practice of the LSK, and the law requires that you submit that evidence as has been said in the case. What you probably will find are some photographs, and then they are labeled Naivasha. Naivasha, they could have been having tea in Naivasha for a different issue, which may have been legitimate, but not this matter. Photographs don't prove meetings. I'm not suggesting the Photoshop, I'm not even going there. But the fact that there were some two photographs doesn't suggest that there was a meeting discussing the matter in issue. I will go quickly to a document that was debated earlier this morning. We were disputing some issues. It's the first respondent supplementary affidavit. Unfortunately, it's not numbered sequentially, but it's the Draft Law Society of Kenya Bill. It's page 3 of the Draft Law LSK Bill. And at page 3, there is a recommendation on the left side and the rationale on the right. It comes from the first respondent's affidavit, as mentioned, and it says this. he or she is a member of the society. I hope that.
No,
this is really critical for this case.
I read this paper.
This is the fulcrum.
Yeah, the papers that were here.
Yes.
I read them. I was here to fight. So when you are talking, I'm reading with you.
I appreciate that. So he or she is a member of the society and has at least 7 years. That was the recommendation earlier. Then to the right there is rationale. So it is 7 years. This is the respondent's own documents tabulated in a matrix. And then the rationale is the chair and the vice should be advocates of at least 10 years because of the caliber of people they have to meet with in the performance of their duty. Of course, the rationale keeps changing, but at least in this paper, that's the rationale that's being given. That rationale ties with what actually went to Parliament and what Parliament says at page 83. I want to tie, my lord, the issue of 2 years for council member and 10, or is it 10, or is it 15 years, or is it 7 years for president? I want to try that. This is a supplementary affidavit of the petitioner. Supplementary affidavit of the petitioner at page 83, bottom, center bottom page, nation. Page 83. Center bottom page, nation. I think that's the third last paragraph. Here, Parliament has received, is saying this, of importance in this bill is the recognition of the LSK by the LSK. Quoting LSK, it has come from LSK, they are quoting, and this is accurate. By the LSK of the young minds, appreciation by the recognition by LSK of the young minds getting admitted to the legal practice day in, day out, to enable them participate in the governing council. Under section 18, a member of the LSK can qualify to become a member of the governing council if they have a practice for 2 years from the date of admission. This is a plus because the young lawyers must have an opportunity to rule, govern, and administer justice to our people through the governing council. Parliament appreciates that point. That point has come from LSK, that point has come from membership. On page 96, Parliament is making its own amendment, not based on, it's not, they are very clear, they're saying we are making this amendment. They are not saying we are relying on LSK submissions, no. While Parliament may have the power to amend some of these bills at certain stages, I'm glad that Senior Counsel Mwite has acknowledged that there might, if it's a fundamental issue, like from 10 to 15, 7 to 15, surely the membership must be consulted. He said that. There must be participation. So you don't just change it midstream. And here you are reversing the very rationale of greater participation, of accommodating the majority of the membership of the society.
My earlier question, during the legislative process,
yes,
even the final reading, even before the bill is passed, Parliament can introduce some amendments. Is it practicable? Let me put it this way. At that point in time, for each and every amendment, whether it's a comma or to refer the bill back to the public for participation?
There are two things about that issue. It turns on Article 24 of the Constitution, which is basically 24 that there must 24.3. The state, you must justify the particular limitation. So on a substantive level, Parliament is further limiting who can run for president. Both Parliament and the LSK must justify that limitation as a substantive question. What genuine occupational requirement is being addressed? Is there any other less restrictive approach? Why not 11 years? Why not 12, which is still higher than 10? Why 15?
Can we agree in the next 5 minutes?
Yes,
we will rush in people,
we will
but
find
I
my
think for the ones who are
five,
coming at
5
9.
minutes is okay. So in that case, and at a procedural level, even if Parliament could make those amendments, there is a statement by LSK that actually these proposals came from LSK. And we are saying that is not true. That is actually, to put it plainly, with some honor, at best, a lie. It's a lie. And the burden is on them. Of course, Mr. Gola was shifting that burden. The burden to prove that there was participation, once it has been controverted, is basically on the agency that claims there was participation. That was the decision, my lord, in the Robert Gakuru case, the Kiambu finance or taxation case, which said what the courts are saying was that whereas the views expressed by the public are not necessarily binding on the parliament, well, that views may not be binding, due consideration might be given to them. Public participation ought not to be taken as a mere formality for purposes of meeting the constitutional threshold. And the burden is on LSK and the National Assembly in this case. Did they give everybody a fair chance to express themselves on this? I think in summary, there was one question which my Lord raised, another question that suppose there is invalidation or suppose there is admission of the petitioner to contest. Will there be a lacuna in case of the invalidation? Of course not. If you strike out that provision, there will be no lacuna, or if you give a different, a more progressive interpretation to section 18 to say practice, yes, there will be no. Because section 12 of the Act, as read with Articles 38 and 36 of the Constitution, guarantee the right to political participation, the right to vote and to vote. And indeed, you will be, this court will be in good society, good company, because the High Court has before, in the magistrate, judges and magistrates case, gave the association 120 days to go, 160 days to go and organize the rules and regulations so that the elections could be conducted properly. Indeed, my lord, there was no submission whatsoever, oral submission, to answer the question of why the society has not facilitated its membership to deliberate on and pass the regulations. They just cancelled SGMs, not given, and then to come here and say that those regulations will not be necessary anyway because the board does not have to deal with it. That's the decision for AGM. That's the decision for membership, because they are the ultimate authority of the society. It's not for council to submit from the bar that in any case those regulations cannot solve these disputes. My lord, lastly, as I sit down, this matter is about constitutional rights and statutory rights under section 12. Arbitration is not necessarily the most appropriate in these circumstances. Also given the timelines, given that there are serious Bill of Rights questions, given the Bill of Rights questions, given the urgency of the matter, among others, the petition approach has been proven to be the most effective. I thank you, my lord.